The recording has started, and we got a chat, we got a Q&A. People are starting to pop in. So we almost doubled from a couple days ago.
Yeah, so
that's great.
Yeah. But they're coming on now, so that you know.
Okay.
Yeah.
Are you letting everyone in the room or?
Yeah, that's fine.
Oh, I see now.
Yeah. Mm-hmm. All right, so I'm gonna go ahead and get us started. And I wanna say welcome to everyone who is joining us for ICABA Live. And today's webinar is about estate planning. And we're going to discuss the topic of planning for the certain in uncertain times. And we are so happy that you've taken the time to join us. Estate planning is probably not the sexiest topic, but I got to tell you, from having lost a wife and a father and a mother and had more than one conversation about the impact of dealing with folks who have had to deal with asset, so they had to go to the state because, you know, they needed Medicare, but then they had to sell off things. And, you know, there are so many things that estate planning can help you to avoid that are painful. So while it may not be the sexiest thing in the world, it may be one of the most beneficial evenings you'll spend in a while. So for those of you who are new to ICABA, we just wanted to share with you that this is the world's leading online community empowering professionals and entrepreneurs of color. And we're doing this to help to enhance your career, business, and your lifestyle.
What can I say about ICABA? It is like the best experience I've had as an entrepreneur. My business has grown to what it is because of the relationships in ICABA.
ICABA is great. It's really a great incubator for connections and business relationships and educating new business people into the world of business.
What is ICABA doing? ICABA is putting you in an environment where you can rub shoulders, you can actually talk to wealth creators, to entrepreneurs who may look like you, who may come from circumstances like you, who may come from an environment like your environment. And then once you go ahead and grab that baton, you might say, well, this is possible. This individual over here did it, and now I can do it. So ICABA is raising our level of vision, and they're doing a fantastic job.
I'm Bill Pickard, chairman of Global Automotive Alliance, and I can't believe what ICABA has done again. Just wonderful people, very energized and very economically and entrepreneurially driven.
Hi, my name is Jermaine Beebe. I'm the current president and CEO of the Greater North Miami Chamber of Commerce. I would say for anyone who's interested and who is looking to network and actually get value out of joining our organization, you will certainly see the value in ICABA.
I encourage everyone to come and just share and just be here and just get to know the people. You know, I've met some fantastic people in my network, have just grown tremendously, and my business has grown tremendously. And it's an organization that just believes in just people who have ambition, people who just really want to go after their dreams. Like, you really can do that here, and people here really support each other. So I encourage you to come. We're excited to support you and all our new members. This is just a fantastic place, and I'm so happy that Jerome executed this vision so perfectly.
So ICABA, our vision for the next several years is that we're looking to become a thriving global network serving over 1 million accomplished professionals and entrepreneurs of color. Our mission is to connect you to relationships, information, and opportunities to enhance your career, business, and lifestyle success. So I want to now introduce you to the two estate planning experts that are going to be sharing with you today their knowledge and their talent and expertise in the area of estate planning. And I am going to first start with the woman of the group. If not, my mom would come down and pop me upside my head. So the first lawyer I'm going to introduce is someone who started her legal career by serving as an investigator with the state of Tennessee, where she investigated employment and housing discrimination claims with the Tennessee Human Rights Commission. She then transitioned her state practice to the United States federal government, where she served as an attorney and representation specialist with the Office of the General Counsel for the Federal Labor Relations Authority. In that capacity, she investigated and prosecuted unfair labor practice charges. She is dedicated to helping families and communities thrive while maintaining fair work environments. After leaving the federal sector, she served as a contract attorney for several large law firms and legal placement agencies, and as a faculty legal advisor for Gallup, the Certified Training and Coaching Corporation. Yearning to get back to her passion of service, her career path took a twist. Her focus shifted from building legacies and serving through fair work environments to creating legacies through estate planning. At that time, she became the lead attorney for the Griffin firm, PLLC's Atlanta office, and fully carried out their mission, empowering individuals and groups to create and protect wealth in order to leave legacies for their families and communities. She took that passion, propelled it forward, and she's now the principal founding attorney of Legacy Legal, LLC, and is dedicated to and passionate about helping individuals, communities, and mindsets thrive. Her estate planning practice is compassionate, empathetic, and thorough. And she's honored every opportunity that she has to help people like you to create a plan, building legacies one family at a time. In addition to her practice of law, she is a member of several colleges and universities, actively involved in the Boy Scouts, has coached Junior Bible Quiz, and is the #1 cheerleader and supporter of her 2 teenage boys and their numerous activities. She has a JD from the University of Tennessee College of Law and a BA in Language and World Business and Spanish from the University of Tennessee, and licensed to practice law in the state of Georgia. Ladies and gentlemen, it is my pleasure to present to some and introduce to others our first speaker, Shannon Wilson.
Thank
Shannon
you.
Wilson is also going to be sharing the stage tonight, if you will, with another interesting individual. And he began his career working exclusively within the taxation field. Originally, while in New York, he worked in the accounting firm of Edward Isaacs and Company and Price Waterhouse Coopers. He moved on to the global tax department at Merrill Lynch, and in 2004, he relocated to Georgia, where he worked in the tax department of Singular and AT&T. He began his law firm in March 2008, and in 2009, his first wife passed away from cancer. That experience caused an expansion of his law practice focus to incorporate estate planning. Over the years, he added elder law to his practice to assist individuals and families to prepare for long-term care and special needs planning. He is a member of the Estate Planning Council of North Georgia. He is also a member of the Georgia and North Carolina chapters of the National Academy of Elder Law Attorneys. He is also a member of the Georgia and North Carolina bars and is a former member of the New York Bar. He's educated through the University of Louisville, I'm sorry, it's my hometown and my home
Go Cards.
of Alabama. In taxation in 2013, he has his MBA from the University of Georgia and his law degree from the University of Mellon. And he also has a BS from Carnegie Mellon. And it's my pleasure to also introduce to some and present to others, Mr. Keith R. Miles. Ladies and gentlemen, Mr. Miles and Ms. Shannon Wilson.
Thank you so much, Hutch.
And I just want to say thank you. We were talking about ICABA. I just want to thank ICABA for the opportunity to do this. And just so everyone knows, Shannon and I are both members of the Atlanta chapter, a part of the advisory board. So we're we feel very strongly about the organization and support in any way we can. So
Right.
ICABA, besides the estate planning, definitely can also ask us about that.
Absolutely. We know that when we know better, we do better. And ICABA often provides platforms for us to make sure that people know better so that we can do better. So without further ado, we're going to kick off and talk about what is estate planning and why it's important and why Keith and I do this all day, every day. We do what we love and we love what we do, but we want to impart some wisdom on you and let you know why it's important to engage in estate planning. So first, I always tell people that a proper estate plan includes both lifetime and at death planning components to account for the possibility of incapacity and the certainty of death. And I'm an attorney. I'm really not that great at math, but I do know two statistics. One statistic, 30% of people will become in some way, shape, form, or fashion incapacitated during their lifetimes. That's pretty staggering, 30%. You think about it, it's really a staggering statistic. 30% of us will become in some way incapacitated. So why engage in estate planning? Because it takes into consideration what happens if you become incapacitated. The second statistic that I know, and all of you probably know it, you just haven't thought about it like this, but 100% of us are going to die, right? 100%. We cannot, there's no way around that statistic. So estate planning takes into consideration what happens when I die, what happens with my assets, what happens with my property, what happens with my children, if I have minor children, what happens if I'm a business owner, what happens with everything that's part of your estate at the time of death. And the third thing that every quality estate plan allows people to take into consideration, and the reason why we should all engage from the time we turn 18, is what do I want my legacy to look like? No two plans look alike. Twins, even identical twins, do not have the same plan for their life, do not have the same plan for what they want their legacy to look like. So we have the opportunity while we are living to paint that picture. I think about it like a puzzle. If you were to be able to hand somebody a puzzle that has all of the pieces of your life in a box, would you hand them the box just by itself, or would you hand them a box with a picture on it? That picture is what you want your legacy to look like. And estate planning helps you create that picture. It helps you put the right pieces in the box, because let's face it, we all have different avenues and areas and facets of our life that don't necessarily, we don't necessarily want to help make our legacy, right? But they're still pieces of our life. So we have to sort all of those things out, put them in the right box, put the right picture on it, so that we can hand that box to our loved ones, hand that box to our business partners, hand that box to our friends and family and anyone whose lives we touch while we're here, so that in that event of incapacity and that certainty of death, everything carries forward.
And I just want to point out, just go 1 second before we go back to that one, Hutch. If I ask a lot of people about estate planning, a lot of people automatically think, well, I don't have enough assets, right? And when you look at this slide, incapacity, passing away, that has nothing to do with your net worth. So everyone needs to do this. It does not matter if you have 10,000 in the bank or 10 million. You could become incapacitated. You could, of course, pass away at any point in time. And part of this too, especially between 1 and 2, you don't know, you have to make a plan that takes into effect that you might die at 40, you might die at 100, right? So you might become incapacitated at 20, or you might become incapacitated at 82. So you have to have a plan that's flexible. So that's why a lot of times we say you need to talk to an attorney, because you can't pull something off of a form or internet and just think it's going to satisfy your needs, when your needs probably need to be customized for various contingencies. So I just want to point that out.
Yeah.
Is it fair to say that maybe even if, matter of fact, if you don't have a lot of money, it may be that much more important to plan.
Absolutely.
If you have plenty of money, you can kind of like spend your way out of it. But if you don't, you might want to make sure you.
Right. Long-term care, especially, I always tell people, I said, a lot of people are thinking about a will and what will I be able to pass on at my death? Well, if you don't plan for incapacity or long-term care, you might spend your life savings.
Mm-hmm.
So you're going to have your heirs will have the will to take to the court, but your assets would have been long gone.
Right.
So you need to definitely plan for long-term care incapacity.
Yeah. Hutch, do we have a survey that we were going to poll the audience on?
Yeah, do you want to do that now?
Yeah, let's do our survey, the first one that we talked about, where we find out who among our participants this evening have any form of estate planning already in place.
Okay, all right. We are launching that poll right now. And so, folks, if you would please take a moment and answer the poll, and it's a multiple choice, so you can answer all or just one. Also, as you're moving along, I'm sure at this point we're getting to the point where people are getting very familiar with Zoom. In some cases, maybe too familiar. That Zoom out thing that we hear these days. But the chat is a good place for you to be able to make comments and share something. But if you have a question, we would like for you to put it in the Q&A. And so please do that. Also, in your, where you have on your screen, you have the ability to raise your hand. So if something comes up that, you want to stop us for or something, please do that. Looks like we've got 4 of you who have answered and we've got several more. So we're only about 50% of the way through here. So if the others of you could please answer the poll, it'd be much appreciated. It is an anonymous poll, so we don't know if this relates to any one particular person or not. And so we would appreciate that. And I think probably while that's going, I think that might be what we're going to get. We're going to get 50%, Shannon. So
Okay.
it looks like I'll end the poll and then I'll go ahead and publish the results here.
Excellent. I love those statistics. That
That's
is
surprising,
by
man.
far tells me that we are talking with people who know some things. Statistically speaking, only about 40% of people of color engage in estate planning, typically speaking. All right. We typically do not do any estate planning. The questions were will, power of attorney, health directive, and trust. And it looks like 75% of those who voted all have those in place, which is phenomenal. That's outstanding. I just really want to applaud everyone for that, because we, especially people in communities of color, do not engage in estate planning. When we think to engage, we're already sitting at the funeral, eating the pound cake off of the napkin with the flowers on it, talking about, oh, I heard mama and them had such and such. At that point, it's too late to talk. It's too late to have those conversations. It's too late to engage. So that's very, very encouraging to see those numbers of those of you on the webinar this evening who have engaged in some sort of estate planning. And with that, we could go back to the slideshow. What I want to remind everyone is estate planning is fluid. It is not a one and done thing. As age, as stages, as life events, as faith, family, fitness, fun, finances, as all of those things change, you should revisit your estate plan. There are 5 times in life where you should absolutely revisit your estate plan. Make that 6. 1, when your age and status changes, when you go from being single person to having children, excellent time. Divorce, excellent time. Disqualification, meaning you were at a job and now you no longer are at that job, so you're not qualified for the plan. Excellent time to revisit your estate plan. Disability, if you find yourself incapacitated or some disability that doesn't incapacitate you, but it changes your life in some way, excellent time to revisit. Departure, upon retirement. People think about and plan for retirement their whole lives, but some people don't think about what that looks like in the realm of estate planning. another excellent time. And then when life events change, such as death, or I'll give you an example of a case that I just was working on. Woman had left everything to her great nephew. She even made him her power of attorney. Nephew got into some trouble and ended up serving a life sentence. She calls and says, "Ooh, I don't think I want him to be handling my finances anymore. And I don't think I should leave my house to him anymore. What if he never gets out of prison?" I said, this is an excellent time to revisit that plan. So it's very, very encouraging to me to see that you all have thought about how to create that legacy. What does estate planning look like? You have to plan. It is strategic. I'm not a chess player, but I know it's a game of strategy. Estate planning is very much like that. You have to plan strategically on creating your legacy, because no two people's legacy looks alike.
So,
You want to add anything on that one, Keith?
no, I mean, you covered it. I want to kind of drive home that last piece where you said that change is sometimes driven by someone else. So if you have your advance directive is your sister and your brother, and they pass away, you now have to update your plan, right? Because, or if they go into a nursing home, one of them goes to a nursing home, they're incapacitated, you now have to update your plan because they were part of your plan. So even though you may still be at the same job, you still married and everything else, if you have people serving in certain roles and they're not able to fulfill those roles anymore, then you need to update your plan. So.
Right. And the plan is one thing, because we plan all day, every day. You know, you hear people say, "Oh, I'm thinking about doing this." That's a plan. Or, "Oh, I'm thinking about doing that." That's also a plan. Or, "I'm planning to do this." That's a plan. Until it is written and in a format that is acceptable by the courts and acceptable by any entity that would need it, it is nothing but a plan. So estate planning involves taking that plan, taking those thoughts, and putting action to them in the form of a legal document that facilitates that plan, that lays out what you want that plan to actually look like. So.
And then one thing, of course, we have to say the standard, if you don't make a plan, especially for when you pass away, the government will make one for you. And that plan will probably not be the one that matches what you would have done. So you, right now, if you don't have a will, you are intestate, what we call intestate. So you have to opt out of that status and make your own plan. So that is if nothing else, just to have your say is a reason to do something.
Yeah, having our say. That was at the Delaney sisters that talked about having their say. When we are young, when we have all of our mental faculties about us, is the perfect time to engage in estate planning. I can't say it enough. Most 18-year-olds don't think they have anything, and they don't, right? But they do have life, and the government, if something were to happen to them, the government would come after their estate. Even if they're doing that through their parents, they come after it. So failing to plan, what is that phrase? Failure to plan on your part does not constitute an emergency on everyone else's. The same thing works in estate planning. You know, like I said, it can be too late. So those documents that we have to have in place, and I'm going to start with the ones that work while we're living, and the ones that we should have in place for that event of incapacity. So the first one, I like to say the plan on this one is that blank check. The plan is the blank check, because what would you do if somebody had access to a blank check? Or who would you give access to a blank check of yours? Or not the blank check, let's talk about that debit card and they have the PIN. Who do you give that to? If you don't have a plan in place, you don't get to give that to anyone. The government says no one else gets to handle your finances. No one else gets to handle your legal issues, because you do not have the document in place that allows that. That even applies to spouses. All right, so what is the legal document attached to that? It's called a power of attorney. All right, Keith, you want to go into that one a little bit more?
Well, the power of attorney, this thing that comes most to mind right away is bank accounts, paying bills. But it's a very broad document, it is it can control your insurance policies, a business, real estate. So it actually has Georgia has a statutory form that has a special section of special powers. So it can control your beneficiary designation, making gifts. So it has the ability to basically not only do day-to-day transactions, but it can actually take your entire estate and move it to someone else. So if you give it to the wrong person, you can definitely change everything that you plan to do, where you thought you might leave $1 million to someone, and it winds up being 200,000 because that agent walked off with 800,000 of your assets. So you definitely want to be. That's the document that's probably the most dangerous, and we have especially with the older population, there's a term you might hear called elder abuse, and that is very prevalent now because the elderly many times need someone to help them do their day-to-day living. So they usually will pick a family member, a trusted friend, and those are the people that will get access, and usually for some of them think that they're entitled to things, or it's okay if they do this or do that. So that's definitely a document you want to watch.
Yeah, and the other part about that is the fact that when I was talking about ages and stages and variations in life that facilitate a revisit of your plan, for instance, divorce is an age and stage and variation of life that impacts all of this. So let's say, for instance, you have your spouse listed as your power of attorney, and you divorce from that person, and then something happens and you have neglected to revisit your estate plan and take them off as your power of attorney. They still have access to that if you have not revoked that power of attorney. So that's one of those events, life events, where revisit that estate plan, because not doing so can be critical. The second document that everyone should have in place, and this I call the God proxy, because it has to do with our health and living and what your decisions would be for your health care should you be unable to express those yourself. And this is what I call a healthcare record, because it has more than one part to it. So the first part of it is where you name a proxy. You name that person that will make your medical decisions for you if you're unable to make them for yourself. The second part is what many states call an advance directive or a living will. And this is where you give that proxy as well as the medical professionals instructions. You say things like, I want a do not resuscitate, or no matter what, I don't want to be fed via IV, or whatever your wishes would be, especially for people who have specific religious beliefs that would precipitate what goes in that document, or people who just have very strong personal beliefs as to what happens with that. For those of you that are in Florida, you probably remember the case that put this on many people's radars, and that was the Terry Schiavo case. And she didn't have these documents in place. She might have had a plan, but she didn't have the documents in place. And Terry Schiavo ended up on life support in a vegetative state for, I want to say it was 14 years, while her husband and her parents battled as to what her plan would be because she didn't have the document in place. Ultimately, we can't say one person lost, the other person won, because ultimately both sides lost all of those years of their life, all of that money, all of those decisions that could have been made had the document been in place to facilitate the plan.
Yeah, this document, I think this is the one that gets the most immediate, like, emotional recognition from people, because they automatically think of that kind of situation. They say vegetative state, I don't want to be kept alive like that, or I have a particular background. We have two conditions in Georgia. One is permanent unconsciousness, the vegetative state, but the other one is the terminal illness. So as they mentioned, I have a background with the cancer with my first wife, and then my mother and my father-in-law. So there may be many people out there that understand that end stage of life period where you're going to need somebody, you're going to get to a point where you can no longer make decisions for yourself. And this is the document that, like I said, there's nothing about money in the estate plan. When these are the things that are most critical, that emotionally mean the thing most to us and the people that we love, to make sure they don't suffer, to make sure that we don't, we do the right thing for them. So you want to have these kind of discussions. And we're going to have some later seminars, the next two, we'll talk about these two documents in depth. So the power of attorney and the advance directive, and we can't really go into all the elements now, but these two require really a lot of thought and who you give the document to. So you're going to express your wishes, but you also have someone who's going to have to execute it and make a decision. And you have to pick that person and not necessarily based on friendship or relation, but whether they're able to do that particular role. So you really have to think through this a lot.
Yeah, and you should name a person or co, although co gets kind of sticky, and then have a successor to them, a backup, just in case that person you named cannot carry out the position of being your healthcare proxy or even your power of attorney. On both of them, this applies. I like to think about the power of attorney being that person that you trust with your money and your finances, and the healthcare being that person you trust with your life. Sometimes they are not one and the same. And nobody, no state out there has a requirement that it has to be your spouse.
And spouse is, you mentioned the power of attorney if you don't change that. But if you're going through a divorce and you're separated, but you haven't filed your paperwork yet, that advance directive is still active. So God forbid something happens to you, that spouse who you're already, like this with, now they have the ability to make a decision over your life. And, they might make some decision at that point, not based on your best interest. Let's just leave it at that.
Right. Yeah. So again, having these documents in place, a celebrity type example of this was John Singleton. He had a stroke on Thursday morning. He didn't have any of these documents in place. His mother rushed to the hospital like most mothers would, even though he was 50-something years old. They said, okay, nice to meet you, but he doesn't have a document in place saying that you can make medical decisions for him. She says, okay, how do I get that? Well, at that point, she had to petition the court for it. The court said, okay, yes, we grant your emergency petition. We have scheduled you for a hearing next Thursday at 2 o'clock or whatever time it was. Emergency petition, and they weren't going to hear it for a week. He passed away that evening, not having gotten the medical treatment that he potentially could have gotten had somebody been listed on those documents to make those medical decisions for him in the absence of him being able to speak for himself. So having those documents in place is critical. So what we've talked about so far is for while you're living. And so a little bit of background, I never wanted to do estate planning because I thought it was all about death. Mind's shift. I realized, no, it's not about death, it's about life and how you live your life and what the quality of your life can look like and how your life can carry on even in incapacity, even in death. So the documents we've talked about so far for while you're living. And the fourth one on there, which is the trust, works while you're living and it transcends with you into death. But the third one is the last will and testament, is the document. The plan is what your puzzle box looks like, right? And what your picture looks like. Most states, Keith already said this, say if you pass away without a last will and testament, the legal word is you die intestate, without it. And what that means is the government gets to decide all the who's, how's, where's, whens of your death. Who gets what, how they get it, when they get it, where they get it, all of those things. The government gets to decide. I don't know about you all, but I don't want the government deciding a whole lot about what I do while I'm living. Much less do I want them to have all of the decision-making authority once I pass away. If I can express that on my own, I would much rather do it than have cousin John, who hadn't had anything to do with my life, rushing down to the probate court because he thinks I have something that he may want and filing a petition and the court granting it. I don't want that. So put it in place ahead of time so that I'm not rolling over in my grave because somebody else is handling it. Or the other part of that, people not filing to probate, and now everything you have is sitting in limbo for years and years, and nobody can do anything with it, and nobody knows how to do anything with it because you didn't put the documents in place.
And when we say the government has a plan, it is literally many times just blood relationship. So many times there's step families where you might have remarried and you have a stepchild that you really love and consider a child that you would want to leave something to, but that state statute just follows bloodlines. So it will not consider that child for an interest. Or the flip side, you may have children you're estranged from that you haven't talked to in 15, 20 years. The statute says, who's the children? Okay, here, you get it. There's no relationship question, whether you got along, that does not matter. So if you have certain situations where you do not want someone to get something, or the opposite, where you want to make sure someone gets something, the only way to do that is to make a will.
Right. In some states, Georgia being one of them, you can disinherit your spouse. Georgia is actually the only one where you can disinherit your spouse. But to do that, you have to have a will in place that either specifically says, I leave them nothing, or just doesn't mention them at all. And then you have your other documents that facilitate, again, it's a plan. The documents have to facilitate that plan. So yeah, you're absolutely right in that. There's a chart in most states that says if a person passes with a will, well, the will dictates. If a person passes without a will, they die intestate, and then they have a chart that says, well, okay, did they have a spouse? Yes, everything goes to the spouse. Or did they have a spouse and children? Yes, everything goes to half to the spouse, half to the children, or a third to the spouse, a third to the children. It's different in every state, in every jurisdiction, but they all have a chart. It's called the laws of intestacy that say if you pass away without that will in place, here, we have a chart that says who gets what. And I just personally, I would not want to be subjected to a chart.
Right. And just to drive it home, I had a potential client that I met with. He had a fiance. She passed away, unfortunately, within like a 2-week period from something that just came on. She was an only child, and her parents had passed away. So the fiance lived in the house with her. The house was in her name. So he was trying to do probate, thinking that he could get the house in his name. Well, the statute is going to find some long lost member of, uncle, great uncle, whoever, that the chart says she would have definitely wanted him to have everything, but she never got a chance to make a will. So the chart says, nope, got to find a family member. If you can't find one that's of a near relation, go, whether it's, 2, 3 rolls over, find some long lost member. That's the way it goes. So we're trying to drive home. You need to make your decisions and control them and document them.
Yeah. There was a question in the chat window about whether these documents override a spousal's decision. I think that is a phenomenal question. And the answer is yes. The document, if you have a document that says I named so-and-so as my healthcare proxy, and spouse is standing there and spouse wasn't named, they're going to look at that document because it is a legal document. It is signed in front of witnesses who say, yes, I know and understand that this is what this person's intentions were. It's also generally signed in front of a notary that says, yes, this is what this person's legal intentions were. Then the document is going to take precedent.
Absolutely. And I think a lot of times when I hear that question, people assume spouses have a certain emotional status to their other spouse. But how many people do we hear domestic violence, just these terrible marriages? And so we can't assume that a spouse is always going to have the best interest of that person. So the law doesn't just default to just saying a spouse is going to serve in a role, because it understands that there are many times that's probably the last person that person wants to be in that role, have a power of attorney over them or advance directive over their person, because they may be in a situation where they're trying to leave that person. So we have to be aware and thinking along that lines that we're going to follow what the person's, we know, like Shannon said, if they sat before someone, had some witnesses, did a notary, okay, that's obviously what they wanted. So we're going to follow that first.
Right, right. And having these documents in place, say for instance, somebody has Alzheimer's and it's early onset. Well, at one point during the day, they may be perfectly capable of making these decisions on their own, but later on in the day, not so much. So having these documents in place early before any sort of diagnoses like those can be diagnosed helps. Because what happens when somebody challenges it, like that spouse that comes in and says, what do you mean they named you as their power of attorney? When did they do that? No, they couldn't have done it then. They were not in their right mind. Now you have a challenge to it. Right. And now that opens up a whole other can of worms. So doing them, making sure that everything is done above board and in perfect timing. So the fourth document that many people should have in place, it doesn't apply to everybody necessarily, but most people, especially people who have minor children, especially people who are business owners, especially people who own property, whether it is still subject to a mortgage or not, should also consider having a trust in place. And a trust is an excellent, excellent estate planning tool. A lot of times it is used to protect assets. A lot of times it is used as a Medicaid or long-term care planning tool. A lot of times it is used for planning with regards to a special needs loved one. A lot of times it's used for planning for our minor children. For instance, if you have life insurance in place, and having life insurance is a portion of estate planning, but it works with the other documents we're talking about. But having that policy in place, say you have $1 million life insurance policy in place, and you want that money to go to your children, and you pass away leaving a 10-year-old and an 8-year-old. I don't know about you all, but I know not one 10-year-old, not one 8-year-old that should find themselves being handed $1 million. So how do you do that? You put it in the trust. You leave the trustee with specific instructions as to how, when, and where to distribute those funds so that said minor children can be taken care of potentially for years to come, for their lifetime.
And also, as we talk about leaving money to the child, if we did it in a will, many times people will just say, okay, I leave the money to my children. Now we haven't addressed who's going to manage the money you left for the child. And it may be managed by someone who will spend it, waste it. So the trust allows you to appoint the trustee, the terms of how the maybe what's invested in, and then how long it stays in the trust. Maybe you say, well, it's going to stay there until age 21 or graduates from college or 25. So it gives you some control to know that it's going to be managed for a period of time. So you give up that control and that ability to say who's going to manage it if you leave it through the will, as opposed to, you can potentially create a trust underneath your will, but it gets a little more complicated. But the trust has a lot of control features that the will does not.
Correct. So there's another question in the chat room that I want to address while it's here. And the question is a living will and the last will the same thing? Again, another excellent question. Yeah. They are not the same thing. A living will is the portion that goes with your health care that says, while I'm living, if this is the medical decision that needs to make, this would be my decision. That's your living will. Your last will and testament says, I've now passed away. This is what my estate consists of. And at that point, it consists of all of your assets, your personal effects, your real property, monetary and physical assets. And it addresses what happens with all of those things upon passing.
Yeah. And you really think about it, they call it a living will, but you would think they'd call the other will a death will, right? But I guess they didn't like the sound of it. Right. So the last will and testament is your death will. And then the living will, like Shannon says, while you're alive. So yeah, that's an excellent question, because that gets confusing. And I think that's part of the reason why Georgia made an advanced directive and took out the living will name, so that people didn't get a little confused. They would know, okay, this is a directive.
Yeah, and all states call it, some states call it a living will, some states call it an advanced directive, some states call it a medical directive. And you don't even realize that that's what they're talking about. You can look at the picture there. It's called a healthcare power of attorney advanced directive. So, you know, every jurisdiction calls it something different, and you just have to know the laws of your jurisdiction or get with an expert in estate planning, an estate planning attorney who is trained and versed in knowing what the ins and outs and details of those laws are.
And I think we didn't really emphasize this in the beginning. This area is the most state specific, probably of any practice area. So a lot of times when we talk, like I have a tax background, so people are familiar with the 1040, so they're familiar with the federal tax code, IRS, so that is pretty standard. This is not standard across state by state. So if you have your documents in place, another part of what we say is to review them is if you know you're gonna move. So if you go from Georgia to Texas, you need to review your estate plan because this is going to function, those same words are going to function differently in another state. So those same documents. In other states, you have a living will and a healthcare power of attorney as two separate documents. You can't even execute those documents separately in Georgia anymore. You have to use the statutory form. So when you start moving state to state, you're going to have some issues.
Right. Now, many states will recognize them from another state as long as they were properly drafted and meet the requirements for that state. For instance, I just had a case where a woman passed away. She had drafted a last will and testament 30 years ago when she lived in New York. She'd been living here in Georgia for the last 10 years. She never changed her will. When she passed away here in Georgia, we had to probate her will here. Well, unfortunately, in drafting that New York will, they didn't have enough witnesses and they hadn't signed in the right place. So the Georgia court said, we cannot verify that this New York will is correct. We had to hunt down witnesses from 30 years ago and provide an affidavit to the court to basically say, yes, this was this woman. Yes, this was her will. Yes, I witnessed her will 30 years ago. Fortunately, they were still living. Fortunately, the attorney who had drafted it remembered the client, and he remembered that at the time when she signed, he had always the same two people witness. And he was able to say, well, this one lives here. And really, we honestly had to go knocking on the door and have them sign so that the Georgia court would accept that New York will. Otherwise, she would have been said to have passed away intestate. And she went through the whole process. She didn't intend to die intestate, but unfortunately, that could have been the end result. So having those documents in place and making sure that they meet the state requirements is key. All right, Hutch, you want to go to the next slide? Oh, great. So we thought it would be a great idea to present estate planning in scenarios, in ages and stages. So we are about to meet young Sue, and we're going to follow Sue through life. And we're going to, at each age and stage of her life, visit her and see what's important with estate planning and what it should look like now. So when we first meet Sue, she's young, she's a professional woman, she's worked hard for her career, and she's loving life. She enjoys her work-life balance, she loves her job, she spends time with her friends and her family and many hobbies and activities. She's dating, but she's not overly concerned about marriage, nor is she in a serious relationship at this time. Let's just say Sue is 23. All right. At this age and stage, should Sue have an estate plan in place? The resounding answer to that is yes, she should. She's young, she's professional, she's working, she has her career. No, she doesn't have a spouse. No, she doesn't have children, but she has life. And with that life comes an estate. So she should have an estate plan in place. So let's talk about what that estate plan should look like at her age and stage. Oh, can you go back, Hutch? Sorry about that. All right, so we talked about the three main documents that everyone should have: the power of attorney, the healthcare directive, and the last will and testament. So at this age and stage in Sue's life, young, professional, unmarried, no children, she should absolutely have at least, at a minimum, those 3 documents in place. She should have that power of attorney in place that says, if she becomes one of those 30% who is incapacitated, she has been able to name somebody to make her legal decisions for her, to make her financial decisions for her when she's unable. Or certain types of powers of attorney allow you to do it when you, like a durable, you don't have to be incapacitated. You could just not want to do it. And your power of attorney can step in and handle those things for you. So that's the first thing she should absolutely have in place. The second thing is that healthcare record. She should have that document in place that names a proxy to step in and make her medical decisions for her. Some people call that a proxy. Some people call it their healthcare power. She should also have the advance directive or the living will that says, if something happens to me, these would be my medical decisions. I want a do not resuscitate, or I want everything but CPR. You know, people say, oh, I heard that cracks your ribs. I don't want that. Okay, again, that's a plan. Put it in writing. She should also have in place the part of it that says, if I can't make my decisions, this would be my decision with regard to my body. Like, I want to be buried, or I want to be cremated, or, you know, she could even leave instructions saying, I don't want a ceremony. I don't want a funeral. I don't want people crying over me. Whatever her ideas are, she should put it in place. The third thing that she should put in place would be that last will and testament. At this point, Sue may think that she doesn't have a whole lot of assets, but like Keith said earlier, whether you have $10 or $10 million, you don't want the state to get it. Guaranteed, if she doesn't put it in place, the state gets that $10, the state gets that $10 million just as readily. So having that last will and testament in place to say what happens with all of her assets in the event of death.
And also, we talked about the main documents, and when we say estate plan, I'm sure Shannon will say too, a lot of people, when we say, all right, only 40% of people have a will, and then we're like, well, how does the whole system not fall apart? All right, because many things pass automatically. So things like retirement plans, so she's working, she might have a 401k or IRA. So that's going to be part of her estate plan, is to make sure that is updated to where she wants that to go. So sometimes I think it's deceptive that people say, oh, well, you're not married, you not have kids. Yeah, okay, but you still have things that could be valuable to pass along. And if she has I'm assuming she has parents that may be around, and maybe she might have somebody she would leave that to that might potentially have some government benefits. Say her father's in a nursing home and he's on the beneficiary designation. Well, she has to do estate planning to make sure she doesn't ruin something for someone else. So even if someone else's situation like this seems very simple and plain, it might be a little bit more once we talk to them and say, okay, well, I'm gonna leave everything to my parents. Well, how's their health? Well, you know, dad's in a nursing home, mom's not so sure. Okay, well, we have to leave it. We can't leave it to them directly. We might have to create a trust and leave it that way. So you have to dig a little deeply into a person's whole situation. So that's where we really, in our process, really say, okay, this part starts with you, but it branches out to family, friends, and other things that you have to tell us what your objectives are. And then we can kind of take it from there to say where we think there might be some risk.
Right, right. Again, no two plans look alike. No two plans look alike. Sue may want to leave everything that she has to her best friend. Okay, that may be her plan. Has she communicated that to her friend, and has she put that in a document that says so? You know, communicating it to that best friend means nothing if there's not a document to facilitate that plan. Because when something happens, like we were saying earlier, say she wants to leave everything to her best friend, but she passes away without having facilitated that document. Now the court is going to step in and say, okay, no spouse, now we're going to go up. Parents, no. Any parents, siblings, and then they start going out. And then they start going out further and up again. And, you know, next thing we know, Sue's estate that she intended to bless her best friend with now goes to a long lost cousin that she didn't even know she had. And so absolutely, age and stage, she is at the perfect age to begin planning her estate, and this will carry her through life. You know, once she starts it, it's starting it, that's the hard part. You know, I'm sure there's people on here that have said, oh, I've thought about this, I've just never done it. Or, yeah, we've talked about it, we've dabbled with it, but we haven't completed it. You know, you have to have action items. And so now is a good time for Sue, young, unmarried, professional, working. Go ahead and start that estate plan.
And also, I want to mention, when we say estate plan, we're talking as attorneys from a particular role in the process. But any attorney that's an estate planning attorney will tell you, we always talk about having an estate planning team. So you're going to have maybe a financial planner, tax professionals. You're going to have insurance professionals. So looking at Sue right now, she might need to, you're a young professional woman, you might want to go talk with a financial planner about some things and talk about how you want to set up the future, talk to your tax professional, maybe life insurance. She's 23, she can get a policy at this point at a great rate. You might want to lock it in now, and the insurance professional will talk about that. So when we say estate planning, it's not only the documents and the beneficiary designations, but it's also the other parts of the process. And we may, as attorneys, not be part of that role, and we have to defer to, there's some things that we can't do for Sue based on what our knowledge base is, and we have to refer to other members of the team.
Right, right. And it is a team. You know, when I'm meeting with clients, it is a team. That certified financial planner that they have, I'm going to communicate with them so that anything I do on the estate planning end for that power of attorney, for that last will and testament, for that trust, anything I do on that end is not going to counteract what they are planning on the other end, on the financial end, or on the insurance end, or on the accounting end. They all work together. It's kind of like driving down I-75. There's lanes. And if you cross your lane without looking, you're going to crash. You know, those of us here in Metro Atlanta see it every day. You know, even in the pandemic, we see it all of the time. So it's the same thing, estate planning. We stay in our lane. We know enough to know I'm veering out of my lane, I'm going to pass the baton. Or a relay race. Maybe an also good example. You know, I run the relay, I got that first leg, I'm going to hand it off to that accountant who's now going to look at everything we're doing, and they're going to make sure everything is in line on that way, on the taxes, on the accounting part, and then they're going to pass the baton to that third person, that financial planner, who's going to, you know, run it, bring it back, and then that anchor leg is going to come up, the insurance, making sure that everything that accountant did, everything that the financial planner did, everything that we're doing in the estate planning arm, making sure that there's coverage for it in the event something happens. So it's like a race, it's like a game. And actually there is a board game called Life. I love that game because it's true. The way that game works is just like it works here. If you do not play the right piece at the right time, you find yourself in probate court. I think there is an actual you have died and now you're in probate court and you have to pay all your money is one of the things on that game. It's the same in real life. So having all of the right pieces and all of the right strategies in place for Sue while she's young, while she's not married, while she's working on her profession, while she's in that growth stage. All right. Life scenario 2. Sue, fast forward, we're going 8 years into the future with Sue. She has met the love of her life. His name is Sam. They have gotten married and they've been married for 5 years now. Fantastic. They both work professionally, but in addition to that, they have that side hustle, that multi-level marketing business that they run. And they purchased their home. They have a 30-year mortgage. They're comfortable, they're happy, things are going great. Yippee, wonderful bliss, marital bliss in their young years. And they decide to have a baby. Junior is born 9 months later. Now, life has collided. Those life events have collided with the other events. And now they, and I say they, meaning Sue and Sam, should revisit their estate plan. We already put the plan in place for Sue. Now let's talk about what that plan will look like now that she's married, now that she has not only the one professional job, but also that side hustle. And now that they have a house, now that they have a child, and what does all that look like? How does it change estate plan? All right, so let's start in order. The first part I want to address is the fact that they've been married 5 years, and I'm going to go back to before they got married. Remember, Sue was young, professional, had a job. So before they got married, they may have wanted to address a prenup, because a prenuptial agreement is going to cover what happens in the event this marriage is dissolved in divorce. And so Sue, young professional, probably earning her income, may or may not have wanted Sam to be privy to that after their marriage. So potential conversation there, and this is one of those conversations that most people either don't mind having or they don't even want to talk about having it at all. Right? But it does go in line with estate planning, because if something happens to Sue or to Sam and they don't have that agreement in place, that arrangement in place, now they fall into the lines of family law, and the judge would be deciding what happens. Say she had an estate worth $1 million when they married, and she doesn't want that to go any further than her direct descendants, not through him or his family or anything else. They probably should have a discussion regarding a prenup.
Shannon, I really didn't think about this before. I took a class once, and when people think of prenup, they're just like, we automatically default to the D part of the divorce part of it. And they say, well, what if I get married to someone, it doesn't work, what do we do with the property? So that is certainly what everyone thinks of with the prenup.
Mm-hmm.
But there's also the death part. You might, your marriage can go fine, and you could stay married for 40 years. That prenup will still handle an aspect of what happens at, after death. So like you said, if they want their property to stay in a certain family or bloodline, it's not doing, when you say a prenup, it's not necessarily that you're thinking the marriage won't work. It might still work. It's just that you want to decide before you go into that marriage where you want the property to go. So right. There's two aspects of it. So I know sometimes people avoid prenups because they say, well, it's like you're saying you're not sure about the love. Mm-hmm. I'm not sure, I'm kind of hedging. Well, no, if you think it's right, you're just making a plan. Like we mm-hmm. keep going back to that word, a plan for what happens. So everything can work out wonderfully. You live happily ever after. But that prenup will then say, okay, at death, that person might give up their elective share or some other thing. So
right,
just want to bring that aspect up.
Yeah, and it also is very important if you're a business owner.
Mm-hmm. Absolutely.
Especially if you're a business owner prior to that marriage, because now your business, remember earlier I talked about succession planning. Right. What do you want that business to look like in the event of incapacity? Right. What do you want that business to look like in the event of divorce? Are they your partner in business? Right. Okay, how did you set that business up? What does it look like? Is my spouse now going to get the other part of that business, or does it go to my business partner? And are we actually partners? Or do we have an LLC and we're both members and our organizational documents dictate what happens? Mm-hmm. This is why all of everything must align. How you organize your business should talk to your estate plan, should talk to your financial plan, should talk to your tax plan. All of them talk to each other if done properly.
Right. And this example, the way it's written, they kind of seem that they're both at the same level. So they're kind of maybe not motivated to do a prenup because they're kind of like, well, I came in here with the same thing you did and we just built it together. But this could easily be an example, like you said, one person could have the business and then they get married. So then they're working on the business that one person brought into the marriage. So I think those situations need to be handled case by case because love is one thing and the business is another. And sometimes they're not on the same page. The parties aren't on the same page. Right.
So that's that part of it. Now they're married, they're working professionally, but let's talk about this multi-level marketing business that they have. They may be working that together as partners. They may be working that together as an LLC. They may be working that together just as a sole proprietors. We don't know what it's structured like right now, but it certainly should be addressed in their estate plans. Sue should make mention of it now when she's updating her plan. She should make mention of it. What do I want to happen with my portion of the business or our business in the event of incapacity? What do I want to happen with that in the certainty of death? Sam should be addressing the same thing. His documents should facilitate the plan that they have in place for that business.
Absolutely. Yeah, this is definitely, when I read this, that's a power of attorney issue. And sometimes people, like I said, if they don't come to us to do the power of attorney, they might get something, some form that doesn't have the right language for them to address running a business. So, or they might get the form and not select the option. They might not understand what they have to select or put in there. So this is definitely, anytime you have a business, I think you have to examine a power of attorney. And also, like you said, the agreement itself, because the agreement is going to really control how, there might be something that says if someone becomes incapacitated, the other partners have the right to buy them out or something. So you can't assume that everything's going to be handled just by what you want. You have to look at the agreement, and these things are going to also require other members potentially to look at something. So you might need to bring a business lawyer in along with your estate planning attorney to start looking at these situations. And then also, we haven't talked about it, but if you have a business, we talked about amongst ourselves, talking about key man insurance and other things. So if you have policies on each other, you got to bring insurance professionals to make sure these things are done right. So this line of this business can bring in a lot of different estate planning elements just by itself.
Right, right. Let's talk about their home that they purchased with that 30-year mortgage. Fantastic. We love home ownership because one thing we do know is there's not going to be any more land on this here earth. So once it's gone, it's gone. Let's keep it in the family. So many times we give up that home. Oh, I don't want that home, even though it's been in the house, in the home for, or in the family, I'm sorry, for 3 generations. And then we have people squabbling over paying the property taxes or things like that. So they should adjust their estate plans to take into consideration that home, even if they're paying a mortgage on it, put it in the plan. Some states will allow you to transfer property upon death in a deed. Georgia is not one of those that allows that. You have to go through probate unless you've taken the individual names off the deed and perhaps moved it into a trust. Then you don't have to go through the probate process. But some states allow that a transfer on death deed or a ladybird deed. So they should now revisit their plans also to take into consideration the fact that now there is a real property associated with them. They should also revisit it to see what that deed they have says. Are they buying that property as joint tenants and it says nothing about rights of survivorship? Uh-oh, that means if something happens to one of them, the other one doesn't automatically get it. Or if one of them dies, the other one doesn't automatically get it. What about that mortgage? How do they have that set up? So many times people think that when a person dies, if the home is still subject to a mortgage, they get it. Well, you still have to pay that mortgage or it's going to get foreclosed on just like any other property that doesn't get the mortgage paid on it. So this is a time to revisit, perhaps, I've seen a lot of this here recently, revisit those life insurance policies so that you have enough life insurance coverage to pay any remaining balance on that home, on that mortgage. And then you can pass it to the next generation. And this is how people create generational wealth through that home, turn it into a rental property. It's mortgage free. 3-4 generations from now, great grandchildren are going to college on that home. So revisiting the plan to take into consideration that mortgage that they have now, that home.
Yeah, this is, when I see that purchase a home, the first thing I'm thinking, like you said, Shannon, is I'm assuming that it's joint tenants with right of survivorship, but sometimes you never know. And I'm a member of 2 bars, Georgia and North Carolina. So in North Carolina, by default, anytime it's a married couple, the state says it is tenants by the entirety. We don't even have that in Georgia. So it's a form of ownership that is only between married couples. And so anytime a deed has a married couple, whether it's said or not, it's automatically that tenancy by the entirety. So it's going to pass at the second to die. So at the first who pass, it's not going through probate. And people don't understand that sometimes. that if you buy a house with someone and make it joint tenants or tenants by entirety, it's not passing to your heirs. It's going to go to the other tenant. So if you have an intent to leave something, especially if it's a second marriage or something like that, and you want to share the property with your spouse, but ultimately make sure some of that interest goes to your children, you need to make sure it's tenants in common and not joint tenants with right of survivorship. So this is an area that we have to talk to people about. Sometimes we say bring your documents to the meeting, and sometimes they don't bring everything, and they're like, well, I forgot to bring that. And it's important that when you meet with your attorney, you bring all these documents so that we can verify how you own something, because there are things that pass automatically, and if we're not aware of what's going to actually happen and we make assumptions, that can lead to bad results.
Right, right. And let's not even, this is a topic that we're going to cover a couple months from now, but that property, if not properly deeded, if not properly transferred at death of the first of them or the second of them to die, it could potentially become what's known as heir property, H-E-I-R property, meaning it's property lingering out there. The person's name on the deed is deceased, and no, effectively, a deceased person can't own property. So who owns this property? It becomes heir property. And so many times, so often, more often than not, I see descendants squabbling over this property because nobody has made a decision on as to who should get it, or this is the more common scenario. People know that so-and-so is living there, and so-and-so's been living there for, since mama and them were young, and they're living there. There's not a mortgage on it. They pay the light bill and everything else, and Big Mama was paying those property taxes. Well, now Big Mama is gone. Everyone's just allowing this other person to live there because they're in the family and they've always lived there, and that's how Big Mama would have wanted it, right? However, if those property taxes are no longer being paid, then the property could be subject to a lien. And then it becomes heir property, even if that was not the intent. The state owns it now because you haven't been paying the property taxes. So, making sure that all of those things are properly set up and scheduled in that plan. I don't think we can say the word plan enough, can we, Keith?
No.
Having it all set up properly so that it doesn't become heir property. And especially now, like I said earlier, we're not getting any more property on this earth. There's not going to be any more land created.
Yeah.
So keeping that property intact, keeping that property in the families, if we can, is preferred. And that way, what happens with heir property is corporations look at it. They just watch it and watch it and watch it. And then they find that one person who they know exists, even though there might be 40 other people that have to be taken into consideration, and they try to buy them out. And it happens, unfortunately. And now that property that could have created generational wealth for a family is owned by a major corporation who didn't even go through all of the proper probate channels to get the property. Yep. All right. So the last thing we want to talk about at this age and stage and scenario with Sue and Sam is baby Junior, who was born during this age and stage. So Junior, now they have to reevaluate. They're not just Sue and Sam, now they're a family unit. So they now need to reevaluate their estate plan. They need to think about, do we have things set up that if something happens to us while Junior is a minor, that he's going to be taken care of financially, he's going to be taken care of physically? Do we have things set up for his schooling? Do we have things set up for his housing? All of those things, everything now has to be revisited. Sometimes now those life insurance policies or those other beneficiary designations that pass outside of probate anyway, now they may want to rethink, okay, do we leave this to one another and a portion to Junior? And if we leave a portion to Junior, how do we set that up so that Junior is not that 10-year-old if we pass away who now has $1 million? So setting everything up to account for that, again, that possibility of incapacity during Junior's lifetime, now having standby guardianship document in place that says if something happens to one or both of us, who becomes the guardian for Junior? It's not always automatically the spouse. You know, again, that's another thing that varies jurisdiction to jurisdiction, state to state. So it may not automatically become the spouse, especially if one of them has named somebody else to step into their shoes and be the guardian. Having that document in place to take to the court and say, you know, I just had this example. My sister is in a coma, and her children don't have anyone as guardian. Okay, but she left this document that says I can be their guardian. Okay, great. The court stamps it. Well, then when sister passed away, she had the document that said she wanted me to be their guardians. It made the process of full guardianship, complete guardianship, it made it much easier because the court already had that person's wishes in hand. Is it always that simple? No, but you can bet that having no documents in place are automatically going to complicate an already difficult situation. Grief can overtake people in a way that you could never imagine. So having everything in order so that people can grieve rather than grieve and have to figure out all of the business of it makes it easier for them.
Absolutely. And this is when we see a child, that's certainly a life event. We say red, you know, big lights that something needs to change, and we automatically think, like Shannon said, about the guardian piece. But we also then have to think about the financial piece because, like she said, we're leaving this child probably funds. Do we want to have the same person that is the guardian be the conservator? Sometimes that's not necessarily the same person that you want to have. You might want to have some checks and balances. I'll leave Auntie to be the guardian, but then maybe my good friend who's the CPA can be the conservator over the funds. So you have to think through this stage of, okay, if something happens to me, all right, I know in one aspect I want this person to take care of my child, but at the same time, you know, I don't want that person to have unfettered access to the money. What some people do, which we definitely do not recommend, is they think, well, so-and-so will take care of them, so we'll just leave them the money directly. My sister will take care of the child, so I'll leave my sister the money. Don't do that, because there's some complications. Obviously, she may not use it the same that you intended, but she may pass away and then it goes through her probate estate, or she may divorce and becomes part of those funds. So you want trust a lot of times when you're leaving money to children, so you can control who is going to manage it for them. Again, how long you want it to be held for them and invested for them. So you always make sure that you take care of who's taking care of the day-to-day, and then also who's taking care of the money. And they may not be the same person.
Right. And this is also a good time to have what I call a child development plan in place. Children do not come into this world with instruction manual. However, in your estate planning process, you can create that instruction manual. What do you want life to look like for them? Do you want them to have piano lessons? Well, leave some money and some instructions saying, I want little Johnny to always have piano lessons as long as he's enjoying it. Or, you know, those soccer lessons, or I want my child to go to my alma mater. Well, okay, we can't necessarily require that, but we can leave instructions, especially in a trust, that promote certain behaviors that we want to carry forward. You know, I'm leaving my child a trust fund in the amount of $2 million, but they don't get it if they don't complete college or trade school or something. You promote behaviors that you would be able to carry forward and promote if you were here to do so. You can't do that without, again, planning and without putting the documents in place for such.
Yeah, Shannon and I, we made a little schedule of different topics each month, and we talked about having a couple of sessions on the family meeting, and especially around Thanksgiving, Christmas, when the family gets together. And some of these things are definitely the things we want to talk about. If you're going to put someone in a role, you might want to tell them and talk about why you're putting them in a role, and maybe when that other person who thinks that they should be in a role is there, they understand that you're going to use person X instead of them, because if they have an issue with it, they can voice it, or you could explain to them why you're not selecting them or not leaving them something, so that it's not a, you know, divisive thing after you pass because you never said anything, and then they're thinking something either is being done that's shady, because that's just the happen. Oh well, I know my mama would have left me something, or they think that if they read the document and something's not left to them, oh well, did they not love me enough, or what? Because people have things they associate being left property with love. So if there are 3 kids and they get 1/3, 1/3, 1/3, and the parent thinks, well, maybe that child's doing well financially, so I'll leave a little bit more to the other kids. And then they're thinking, well, did mom not love me as much as anyone else? So you want to have these kind of discussions while you're alive with your family. So we're going to have a couple of sessions on the family meeting and talk about especially the psychology of leaving people things.
Yeah. Families are not always functional. Families are not always dysfunctional. Sometimes that dysfunction is how that family functions. So, every family, your family dynamics probably better than anyone else. If you know that Johnny is the one who always screws up everything, believe me, Johnny knows it too. And so he's not going to necessarily be surprised. There may be a little bit of hurt in there, but he's not going to be surprised when you don't leave him all of that. They know it just like everyone else knows it. So yeah, having those discussions, planning for Junior, even when Junior is a newborn. Other persuasions have their children born with, you hear about the phrase being born with that silver spoon in their mouth. There's no reason why we can't do the same thing. It's just a matter of planning and knowing, like I said earlier, when we know better, we do better.
And I'm just thinking, we were getting a list of questions, and one of them was why. I think what was the exact question? Because it popped in my head, and it was why do the courts allow wills to be contested when the person filing her will is doing the aid of an attorney? And a lot of times things get contested because someone gets mad at what they were left or not left. So is the court, we'll have a whole probate session in the heir property and probate. So we'll kind of talk about what the process is designed to do, but it's basically proving the will. So if you have a will, you have to go take it to the court, and they have to prove that it was done, executed correctly. Like Shannon says, sometimes the witnesses aren't right or something is wrong. But if the will itself is okay on the surface of the document, sometimes people say, well, I know that, so-and-so wasn't in the right mental health, or they had some undue influence. So they allow the people to challenge a will so that they can make sure that, the court's doing the right thing, and everything's out in the open. But what happens sometimes is if someone's not left what they think they should be left, because you didn't have that conversation with them, then they're like, well, I'm not accepting this. So then they start doing challenges. So that family meeting is that time where you get, you get it all out in the open. Hey, I'm not going to leave. I've given you enough. Maybe hey, I've helped you along all these time, and I've paid for this, and I think I've given you enough, and that's it. So that I just want to address that question, because it seems maybe to a layperson like, why you have an attorney, you have this will that you bring to the court, why is it not enough? Well, the court allows for, people do bad things. Sometimes people hide wills, and sometimes people change things and force people to change things that are not in the right mind, right? People get older, and then they say, don't you want to leave me something? And things change, so they handle that. But a lot of it is just people thinking they should be left something, and they didn't get what they think they should have been given.
Right. And so I always anyway, put a no contest clause in there. And so if anyone challenges it, they're treated as if they predeceased you, as if they died before you, and then they get nothing anyway. So it behooves them not to challenge it.
Well, there's part of that too, is if you put a no contest clause, you can't leave them nothing, because they have nothing to lose, right?
Right.
So you have to leave them very little, or at least enough that they'll risk it. They're like, was it worth risking what I've been given, even though it's not what I wanted? But if you say I leave you nothing, then they'll say, well, okay, I'm definitely contesting it because I get nothing either way, so I'm gonna just try it, right? So you have to have a strategy in that to say, okay, I'll give you just enough to make you wonder if you should contest it. So it's kind of, you gotta go through that.
Right. So I think we have gone through 2 ages and stages of life. We have 3 more, but before we go over those 3 more, I think we're going to take a little break and give you time to stretch your legs and do whatever you need to do. And we are going to reconvene in 5 minutes, Hutch, or 10?
5. Yeah, it's well, I tell you what, it's 8:24 right now. So why don't we just have everybody back at 8:30?
Sounds great.